shall be an elected person and shall hold office for a fixed term. The President of India is the chief executive head of India. So that is what it states. So, nature of Indian state. When I'm saying nature of Indian state, we have sovereign, socialism, secular, democratic, and republic. So this is preamble, and it is also the nature of the Indian state. And when we are talking about the directive principles of state policy, so what are directive principles? So these are nothing but the directions or the instructions which will tell the legislature and what can be executed and what can be done. So the essential purpose of these directives is to guide the courts to go in the right direction while implementing the laws for the welfare of the state. So the government has to keep in mind certain principles which were shaped by the constitution related to directive principles of the state policies. So unlike the fundamental rights, the directive principles of state policy are non-justifiable, which implies that no action can be brought against the state before a court of law for its failure to implement the directive principles. Now, let us see what are directive principles. Socialist and economic principles. So these two principles are continuously focused on shaping our country into a welfare state. And what kind of objective does this particular point has? So it to ensure the state shall direct its policy in securing adequate livelihood for all the citizens, regardless of men and women, equally. So there's equality of gender, distribution of resources and wealth among all the classes equally, men and women paid equally for equal work, full employment, workers' participation in the management of activities and establishment, protection of children, youth against exploitation, and compulsory education, equal opportunities for equal status for all, and public health, importance of public health, safeguards the forests, environment, and wildlife of the country, and common civil code. Okay. So the Gandhian principles, when we talk, the principles followed by Mahatma Gandhi during his lifetime were covered in Article 40, Article 43, Article 47, and 48. So, to fulfill Gandhiji's dream, the constitution designers consider these principles in the constitution, and the state has to implement self-government, village panchayats, and cottage industries in the rural areas, ban on consumption of drinking alcohol and drugs, equality in the society when it comes to education and economic benefits, and the benefits have to be provided to the weaker sections, and particularly the SCs and STs, and implement new scientific methods in animal husbandry and agriculture, and protect cows and other useful cattle, and protect the wildlife of the country, national, and also maintain the places of national historical importance, and distinct the judiciary from the executive. So international principles will say, as per Art 51, directs the state to encourage global harmony and security, to sustain good relations between nations, to respect international laws and agreements, and to settle international disputes by arbitration. So these are the international peace and security aspects which are covered. And coming to the fundamental rights. So what are fundamental rights? These are the group of rights that have been accepted by the Supreme Court as requiring a high degree of safeguard from government, and the Constitution identifies that these rights specifically or have been found under due process laws influencing on the fundamental rights. So what are the fundamental rights? Let us see. The right to equality, this is dealt from Article 14 to 18. Now, equality before law, equal protection of laws, and prohibition of discrimination. It can be either on the grounds of religion, race, caste, sex, or place of birth, and equality of opportunity in public employment, abolition of untouchability, and abolition of titles. So these are the rights to equality which are covered from Article 14 to 18. And coming to the right to freedom, Article 19 to 22, it is the freedom of speech and expression, assemble peacefully, form associations and unions, move freely throughout the territory of India, reside and settle in any part of India, practice any profession and carry any occupation, trade or business. So when I'm saying protection in respect of convention for offenses, right to life and personal liberty, right to education, and protection against arrest and detention in certain cases. So this is covered from Article 19 to 22. And the exploitation, the right against exploitation is covered from 23 to 24. That is prohibition of traffic in human beings and forced labor, and prohibition of employment of children in hazardous jobs. And then you have the right to freedom of religion from 25 to 30, and the freedom of conscience, free profession, practice, and propagation of religion, freedom to manage religious affairs, freedom to pay taxes for promotion of any particular religion, and freedom to attend religious instructions and place of worships. So here, the next right being the cultural and educational rights. These are from Article 29 to 30. It can be the protection of language, culture of minorities, and the right of minorities to establish educational institutions, and right to constitutional remedies is from Article 32 to 35. So based on this, right to move to the court of law to issue directions, orders, writs for enforcement of rights. So in this way, the articles are divided, and the Constitution of India embodies the noble and grand vision of liberty, equality, and fraternity, and promise to secure social, economic, and political justice. So when we see the right to life and personal liberty, Article 21, it is yet another important provision of the Indian Constitution, which provides that no person shall be deprived of his life and personal liberty except according to the procedure established by law. So this is based on the law where you have the right to life and personal liberty, and the right to live includes the right to live with human dignity and all that goes along with, like, the necessities of life, such as adequate nutrition, clothing, shelter, okay, and the facilities which are, really required to live. So all these things are covered under the right. And coming to the directive principles and fundamental rights. So the fundamental rights are different from directive principles of state policy. So both are related to socio-economic guidelines, directive principles of the state. They look into the establishment of equality and justice in the society. And if there is any violation against the fundamental rights, an individual person can appeal to the court of law and get legal assistance through the courts. And directive principles instead need legislation for their proper implementation. So there is no law carrying out the policy that that is laid down in the directive principles. So, and fundamental rights are routinely imposed. And when it comes to the directive principles, the focus is on the overall development of the society and economic equality, whereas the fundamental rights, they pursue to create political fairness. All directive principles are positive, and some of the fundamental rights are positive and negative as well. The directive principles aims to establish economic security in the society, whereas the fundamental rights are political, and these rights guarantee some of the democratic rights to the citizens. And some fundamental rights of the citizen remain suspended during national emergency. But the question of suspension of directive principles does not arise during an emergency or at any particular time. And fundamental rights are not absolute, and citizens are subject to reasonable restrictions. On the other hand, directive principles are not subject to any constitutional limitations based on political, with the government may or may not implement them. So fundamental rights are enforceable by the courts, and the courts cannot declare as void any law which is in conflict with any of the directive principles, because directive principles are not enforceable by the courts of law. And in case of conflict between the fundamental rights and directive principles, the former gets more priority in the court, and the fundamental rights are more precise and concrete, whereas directive principles are of wider significance. So whenever we see the rights and principles, so this is where the discrepancies arise. And coming to the fundamental rights and labor legislations, so the concept of equality before law is illuminated in the Article 14 of the Indian Constitution. And it is not possible to achieve absolute or actual equality among the human beings. And to achieve this goal, many factors need to be synchronized, streamlined. Unless this is done, you cannot have the implementation of the above statement. So it is a conception indicating that the absence of special privileges because of birth, creed, or the like in favor of any individual, and also the equal subject to all individual classes to the ordinary law of the land. And Article 16, subsection 1 and 2 of the Constitution affirms equivalent occasion to all the residents in the matter of arrangement in any office or some specific work. And Article 3 and 4 and 5, they set down by the way of exceptional cases wherein sensible grouping and arrangements which are for the strict establishments is dealt. Article 19 in its different sub-provisions gives the opportunity of affiliations, opportunity to carry on an exchange of business, right to speak freely of discourse. Okay. And Article 21, it says that no individual will be denied of his life or individual freedom besides as per system set up by the law. And Article 23 and 24 assure the privilege against misuse. Article 24 of the Constitution restricts the work of children under the age of 14 years in the processing plants, mines, or some other dangerous works. So Article 32 to 35, they have the assurance, the privilege to protect cures as a privilege without a cure. It is a useless custom. So the cure makes the correct genuine, and the Supreme Court has developed the creative system of empowering public interest litigations. And when we talk about the Constitution, and the Constitution is the supreme which will try to govern the country. The labor laws are also made according to the Constitution, and any violations of the constitutional laws will be result in the abolition of a particular law. So in simple terms, Constitution is set of laws, rules, or principles by which a country is governed. Now coming to the next subheading, Indian labor legislations and framework. So industrial law has been preserved through a change concerning its object and scope. So when we are talking about the early industrial laws established were to protect the interests of the employees, and the rule of laissez-faire directed it. So when we talk about the modern industrial legislations, they are focused on shielding workers against exploitation by the employers. And it has started with the policy of well-being. State was developed on the trust, and it is advanced on social philosophy. And the philosophies of hire and fire, supply and demand, and these things have gained more importance in the period. And coming to the scope of labor laws, the labor laws play a critical and crucial role in the corporate area. So, due to the existence of the law in the workplace, employees have treated appropriately, and they have their rights, and employees are secured by the labor laws, given the assurances and guarantees. I mean, in a way, the labor laws protect the employees. So, what does the book of Otto Clarence has mentioned? So the following points have been mentioned: the system of collective bargaining, wherein all the workers together, all the unions together approach the management and bargain for the benefit of the employees themselves, and the laws governing the labor relations. It can be the courts, labor courts, or it can be the tribunals, or it can be the courts of authority. They all have been established to protect the interest of the employees, and it is a social part. Okay, so a true labor, the labor laws will be covering the aspects of legal system. In a way, the labor laws will try to frame the rules and regulations wherein the employees can be protected from the employers. Now, what do employers do when it comes to the labor welfare measures or the working conditions, or it can be relating to the payment, or it can be relating to the gender, or it can be relating to the place of work? So anything. So the labor laws will try to protect. They have the power, they have the protection of the employees by enforcing the laws. They try to take the employees on a better hand and protect them from the employers. Now, when it comes to the importance of the labor laws, the government enacts labor laws to provide economic and social justice to the workers. And what are the essential points which cover that? So employee rights are protected. So the work environment, employees have rights to be protected. So it can be the reasonable working hours, lunch and leave breaks, as well as healthy environments. And it will also protect employees from exploitation in the workplace, wherein you have the clearly defined leave policies, sick leaves, which are there in the HR manual, so on and so forth. And employee skill development enriches the business. So the human resource development needs to design the employee development programs to ready the employees to the existing development. And they need to have the training sessions and initiatives which will actually develop the staff in learning new techniques, new knowledge, which can be utilized in the production process. And higher employee retention rate, where you need to see that your employees are not leaving your organization. Okay, the labor turnover or employee turnover is less, the rate of turnover is less, and the retention rate is high in the organizations. And labor laws also contribute to the business success. So a peaceful connection between the employers and the business. So generally, when we say they are, that is, whenever we talk about the law will try to protect the relationship between employees and employers, between employees and employees, as well as between the employers and the government. So together, employees, employers, and government should work together so that they have a contribution to the success of the business. And when we are talking about the labor policy in India, labor plays a major role in maintaining the productivity and management of the country. So the main task of our government is to increase their contribution in the national development, and this will directly depend upon the workers of the country. So the labor legislations are necessary because the workers are weak. Economically, they are weak. They cannot bargain. They cannot negotiate with the employers. And with the poor bargaining and negotiation abilities, the workers are always exploited by the management. So it is the major job of the labor legislation is to bargain for the part, for the health, for the facilities and the safety and welfare of the workers. And the role of the labor is mostly, it comes into the picture at the time of British colonization, when the industrial revolution started in India. So when we talk about the condition of the workers or the laborers during that time, they were highly exploited and they were in a very bad shape and condition. And hardly they paid proper wages, and there were no breaks. And 16 to 18 hours they used to work without a break and no leaves. And so they deprived the basic right. And because of the cheap labor, Britishers exploited Indian workers to an extent that they could gain more, and the workers were not given anything. So this has affected not only affected the Indian labor, but also the British Parliament. As competition increased to British textiles and exports market, they were forced to use the Indian labor. And when British Parliament has passed the Factories Act in 1883, which deals with their basic rights like 8 hours of work, child labor abolition, extra wages for extra work, and then this was the point where the journey of the labor laws has started. And there were various acts which were passed by the Britishers, such as Workmen's Compensation Act 1923, Mines Act 1923, Forced Labor 1930, Payment of Wages Act 1936. And the moment India got independence, the government provided various new rights to labor, so which provide them equality and increase of their social status. So the labor policy in India comes from part 4 of the Constitution, which is the directive principle of the state policy, and which is based on certain fundamental principles such as social justice, social equality, and we also have international uniformity. Now, what is the social justice? So it will try to provide justice, means equal distribution of profits between industries and laborers. Equity, social equity, which says that fill the gaps in the law as per the requirement of the society. International uniformity, it will check the role to check whether any law follows this principle or not is checked by the international labor organizations. And the main aim is to remove the injustice and to improve the working conditions of the labor, and also to provide equality amongst laborers. And we have the postulates by the labor policy, which says that state has recognized as the custodian for the interest of the community, to treat laborers in a peaceful way, and if justice is denied to them, and to make such governing bodies that work as a tool for providing justice. And it is the responsibility of the state to favor the weaker party first, and to maintain industrial peace, to provide fair wages, to enhance the status of the workers in the industry, and also to create new jobs. So the classification of the labor laws, there are more than 100 legislations which deals with the labor laws in India. Therefore, the classification of labor laws is very, very important. So what is the classification? The former type of classification which has listed the labor laws enacted by the central government, and the labor laws enacted by the central government and the state government, and the labor laws enacted by the state government and enforced by them only, and the laws which are enacted and enforced by various state governments which apply to the respective states. Okay, so the first criteria is the enforcement solely lies on the central government. Second, where the enforcement lies between central and state. And the next being the laws enforced only by the state. And the last, which are various state governments which will be applying to their respective states. So the other type of classifications can be laws dealing with the industrial relations, laws dealing with the remuneration, payment, and deductions, laws dealing with the social security of the employees, laws dealing with the nature and conditions, work environment, weekly holidays, laws dealing with the issues of the gender equality and women empowerment, laws dealing with the social evils and prohibition of the bonded labor, child labor, etc., and laws dealing with the employment and training of the employees, so on and so forth. So this is the classification which is based on the enactment and enforcement. So the first one being the labor laws enacted by the central government, and the central government is the sole authority or the responsibility for the enforcement. Like you have the Employees State Insurance Act 1948, and then you have the Employees Provident Fund and Miscellaneous Provisions Act 1952, the Dock Workers Safety, Health and Welfare Act 1986, the Miners Act, the Indian Ore Miners, Manganese Ore Miners, the Mica Miners Act, and the BD Workers, and you have the Limestones, the Cine Workers Welfare, and you also have the other acts which are enacted to protect the interests. And then you have the labors which are enacted by the central government and enforced by both central and state. We have the Child Labor Law, the Building of and the Construction, the Central Labor Act, the Equal Remuneration Act, the Industrial Disputes Act, the Industrial Employment and Standing Orders Act, the Inner State Migrant Workers, the Labor Laws, Maternity Benefits, Minimum Wages Act, payment of bonus, payment of gratuity, okay, payment of wages. So these are all enforced by both state and central government. And then we have, which are enforced by the state government, are the Employers Liability Act, the Factories Act, the Motor Transport Workers Act, the Personal Inquiries, the Personal Inquiries Compensation, Emergency Provisions, Sales Promotion, the Trade Unions Act, the Weekly Holidays Act, the Workmen's Compensation Act, the Employment Exchange Compulsory Notification Act. So all these are by the respective state governments. So what are the objectives of the wage laws? The first and foremost objective is the economic objective. So these goals focus on viable pay strategies, okay, and it requires high national income. It requires the national income which should be spread amongst the individuals of the nation. So it can be the community outright to have high level of payment security, full and complete employment, ideal distribution of all resources, and stable economic progress. So social objectives. What are social objectives? Economic and social objectives have close interrelation. So whatever measures which are inspired by social considerations inevitably have economic effects. So when you are providing economic benefits, automatically those will be relating to the social, like abolition of inadequate wages, formation of impartial labor standards, protection of wage earners from the effects of rising prices, incentive for workers to improve their industrious performances. So these are all the social objectives. Now, what can be the labor laws relating to the wages? So the Payment of Wages Act 1936, the Minimum Wages Act 1948, Payment of Bonus Act 1965, and Equal Remuneration Act 1976. All these are the brief outlines of various laws which will be relating to the wages. So what is Payment of Wages Act 1936? The act is a defensive bit of legislation wherein Payment of Wages Acts, it will try to have the specific class of workers working in the organization. It deals with them. The fundamental objective of this act is to guarantee the worker payment of their required or acquired wages on the date without an approved reason. So it is the timely payment of the wages, and it will control the manner of the payment of wages at normal periods. So in an economy where even minimum wages are not paid to the workers or laborers, the need to secure the wages earned by them has been given importance, and this act is considered as one of the significant social security measure towards the welfare of the workers, towards the welfare of the laborers, to the to protect the interest of the workers against the mismanagement of the employers. And then we have the Minimum Wages Act 1948. So the Minimum Wages Act is that the industry wherein it has to decide the minimum wage which is required for the livelihood of a worker. Okay, so it can be a commitment given by the employer. It can be as economic or social, where the employees will be protected and will be given the wages in such a way that at least maybe good working conditions and good living conditions, wherein you have the minimum wages which are being guaranteed and assured by the employer. And coming to the scope and the coverage of the act applies to entire India. So initially it was spread to agriculture work and 12 different businesses which are scheduled in the act. Now, the object of this act is to promote the welfare of laborers by fixing minimum rates of wages in businesses. And when uh, the act was challenged in the year 1955 in the case Bijoy Cotton Mills and State of Ajmer. So when the constitutionally this was questioned, which was challenged in the court of law, where the constitution observed that securing of the living wage to workers is ensures not only the bare subsistence but also maintenance of health, decency, and it will, in the general opinion, a wage which will try to meet not only the base substances in the sense food, clothing, and shelter. Apart from that, it also the money, whatever the wage has been earned, should be sufficient for securing minimum health benefits for the living of the person. So this is what the scope covers. And the payment of the Bonus Act 1965. So it is a bonus. This forms 8 to 10% of the total earnings of the worker. And what is bonus? It is the share of the profits which is given to the workers. And again, the real wages payable to most of the workers in India have not reached even the pre-war 1939 level. So the annual bonus will continue to play the part of filling the gap between the existing and the living wage. So the act covers the whole of India, whereas in the establishments, whereas 20 or more persons are employed on any day during the accounting year. Then you have the Equal Remuneration Act 1976. So the discrimination based on sex regarding the payment of wages, that is the gender differences, have been one of the most prevalent unfair labor practices. So when it comes to male, the payment is different. When it comes to female, the payment is different. And when it comes to child, the payment is different. So the Equal Remuneration Act 1976 has come into picture, wherein to reduce the discrimination between gender and provide equal opportunities to each worker, even coming to the compensation. And again, it applies to whole of India, and it applies to the payment of wages to person employed in any factory. And moreover, these acts try to protect the interest of the workers when it comes to the payment. And laws relating to industrial relations. So when we talk about the laws, we have the Trade Unions Act 1926. So besides the Bombay Industrial Relations Act 1946 and the Maharashtra recognition of the trade unions and the Prevention of Unfair Labor Practices Act 1971, the Trade Unions Act 1926 is the only legal frame for the trade unions, which have the right of association, and they have the organizing unions. So it permits 7 or more persons to form a union. You can have multiple unions. There is no restriction in the number of unions, but the minimum number is 7. And it can be either a registered trade union, or it can also be unregistered, but generally the registered trade union has more options whenever there's a case or something which is pending in the court of the law. And the act extends to whole of India. And a trade union is nothing but it is a combination of whether temporary or permanent uh, employees formed primarily to regulate the relations between the workmen and the employers, or it can be between the workmen and the workmen, or it can be between the employers and employers. So any kind of uh, injustice done to the workers, they can approach the trade union and get the actions rectified. And then you have the Industrial Disputes Act 1947. So any particular dispute, I mean, what is a dispute? It can be a problem. So any problem or any action which results in industrial disruptions, or the peace is disrupted, then to maintain harmony and to maintain a quick procedure of resolution of the problem, the Industrial Disputes Act 1947 is one of the way where you can negotiate. Either you can go for the negotiation, either you can go for the conciliation, or either you can for the adjudication, arbitration. So many steps are there where you can resolve your issues, either workman, employer, workman, employer. So any of the issue can be resolved with amicable discussion under the Industrial Disputes Act. So the basic objectives of the Industrial Disputes Act is promotion of measures for securing unity and good relations between employer and employee, and investigation and settlement of the industrial disputes, prevention of illegal strikes and lockouts. So strike is the weapon of the union, and lockout is the weapon of the employer, and layoff, retrenchment. So any of these can be avoided by promoting proper collective bargaining. And then you have the Industrial Employment Act 1946. So Industrial Employment Standing Orders Act was introduced for the employers in industrial establishment to ensure the employment conditions under the establishments. So standing orders states the law which govern the relationship between the employer and the workman, and it includes the elements such as classification of workers, working hours, attendance, suspension, termination, etc. Any aspect related to the work. And then you have the industrial discipline and misconduct. So industrial discipline means working by employees according to the rules and regulations and code of conduct in the industry. And it signifies order lines. And if these are not followed, if these are not obeyed, resulting into the misconduct. So whenever workers disobey the rules, or they are unwilling, they are reluctant, so the behavior is not standardly acceptable or appropriate. Under such cases, the Industrial Discipline and Misconduct Act will take place, see that the things are running smoothly. So the misconduct can be relating to the specific words or specific connotations. We cannot define the misconduct from the point of view of just a saying. It depends upon the work or the work sphere. And under Indian Penal Code, we also have certain laws. So the misconduct which is defined, like any action which is called a misconduct, can be regulated under this particular act. So it can be the domestic inquiry. So an employee accused of misconduct gets his day in the court via domestic inquiry, whereby the employer has to prove the charges, and the worker will also get defend himself. Even he will also try to prove that he's innocent. Okay, and the domestic inquiry, usually called as DIE, is an wherein internal hearing is held by the employer, and he will try to gather the facts and materials wherein to claim the employee is guilty of the misconduct before, and based on that, based on the inquiry, a show cause letter will be issued. And once the show cause letter has been issued, it is mandatory to give a response to the show cause letter. And once the show cause letter has not been answered, then there's a notice, issuance of the notice will be done by the domestic inquiry. And in the period, you will be, the person will be suspended, and you have the appointment of the panel of domestic inquiry. It's a panel of the members who try to come forward and try to listen to the parties and give the justice fairly. And once the domestic, at the stage of the domestic inquiry, unless the misconduct is valid and proved, I mean, you have to prove it, whatever is happening, whatever has happened and proved and valid, to claim the employee to be guilty. So the deal of the act will be fair, and justice will be provided. And what is the need for the labor welfare in India? Labor welfare is largely influenced by humanitarian principles and legislation. So on the humanitarian grounds, generally what all we have discussed till now, employees are, or workers, they have weak bargaining power, and majority of them, they don't know the basic information about the law. So they are being exploited by the industries and by the organizations. So for that, I mean, either it can be the gender discrimination, or either it can be the pay discrimination, or it can be the opportunities denied, or it can be the child labor, or it can be the welfare measures, or it can be the pay disparity, or it can be the, I mean, the leave policies or the holidays, anything. So whenever we are talking about the welfare, so when the employees or the workers, if they are deprived of their basic amenities, I mean, some law should be there to protect them against all these. So that is where we have the necessity of the labor welfare. And what can be the benefits to labor and industry? The labor welfare which concerns with the workers' health, safety, comfort, and efficiency. It will try to provide better working conditions, a safe place to work, a healthy place to work. So these can be the restrooms or washing or bathing facilities. It can be the creches, that is the daycare centers. It can be the rest shelters and canteens. Arrangement of pure drinking water or good drinking water facilities, and arrangement for prevention of fatigue. So when you're working with the machines, I mean, you need some kind of a rest in between. So you need to have some kind of an arrangement for that. Health services, uniform, clothing, protective clothing, gloves, or it can be helmets or glasses or whatever it is, and all the administrative arrangements within the factory, which will take care of the welfare of the workers. And when it comes to the industrial health and hygiene, so occupational health and safety management can be meaningful if it is implemented in the organization. Hygiene is very, very important, where you cannot have any diseases due to unhygienic conditions, or it can be the it can be the drainage system, or it can be the waste material disposal. And when it comes to the occupational health and hazards are unavoidable. Like, for example, if you're working with cotton manufacturing or the cotton wool separation, definitely you get the lung infections or the breathing problems. So occupational health hazards should be taken care, and whatever protection can be provided by the employer to safeguard against the occupational hazards should be taken care by the industry. So health and safety are one of the most critical aspects of the organizations. So the main objective is to provide a statutory framework which will be enabling the legislations to all the sectors, and it provides administrative and technical support services, reduce the incidence of work-related injuries or fatalities and diseases, also reducing the cost of workplace inquiries and diseases, and community awareness. So the Occupation of Safety, Health and Working Conditions Code 2020, it provides the following: the labor laws under one single code with 143 provisions, that is the Factories Act, Mines Act, dock workers, building, plantation, contract laborers, the BD workers, cigar workers. So in that case, the common code has been made so that under one single code, the law can be enacted. And the applicability is at least minimum 10 workers should be employed for all mines and docks. And it provides special provisions like types of establishments and classes of employees, factories, building, construction workers, so on and so forth. And we also have National Occupational Safety and Health Advisory Board. And the board will have a tri-party representation from trade unions, employers, and state governments. And they have the implementation of the code from their side. And we also have the licensing requirements: one registration, one license, and one tax return instead of multiple registrations in the existing 13 labor laws. And we have the formalization of the employment. The code provides a statutory provision to issue the appointment letter to every employee of the establishment. And we have the safety and welfare provisions which are there. And the duties of the employees are defined. Working hours for women, the penalty if the law is not followed or enacted. And these are all, if what kind of penalty, the court may direct at least 50% fine as a compensation to the heirs of the victim if suppose any accident or any health hazard happens. And if the result action is the death of the employee, 50 lakh rupees or 2 years fine might be, 2 years imprisonment might be levied. So there are certain laws which will try to protect the employees. Whenever there is anything going wrong, the court will come forward and try to see that there is proper justice done to the employees. And we also have the miscellaneous provisions of working conditions. You need to have the process of declaring the dangerous operations in the industry, restricting the employment of women and children, protection, protective gloves, protecting tools to protect the workers or the employees from working certain works. And we also have notice of certain accidents. Whenever certain accidents, you predict, where in any factory accidents occurs, the cause of death or the causes of injury, or it can be the any result, the person injured from working for 48 hours or more, immediately after the accident, the manager of the factory shall inform the prescribed authority saying that this is what has happened, and the employee or the owner has to take the part in the management place whenever there is an accident which has been occurred. Okay, so there is a procedure for, it has to be followed by the organization and by the management. And also it is important to give notice of certain diseases while you work in the industry or the organization. So what kind of diseases are expected, and providedly you have to take precautionary measures with proper ventilation, temperature, humidity, cleanliness, and hygiene. So these are the things what you have to provide while working. These are the recent amendments which are proposed to the labor laws, the code on wages, the code on social security, and also the occupational safety, health and working conditions code and the industrial relations code. So these have been proposed to be added to the labor laws. And we also have the code of wages 2019, which actually specifies the definition of the wages and the employer and employee. Similarly, the code on social security 2020 is there, occupational safety and health is there, industrial relations code is there, which will actually try to protect the employees. And these all have been the recent which have been added in the year 2020. So with this, we completed 2 units. From the 3rd unit, we are going to start tomorrow. Thank you.
Thank you, ma'am.
Thank you, ma'am.
You're welcome, ma. Thank you.